My name's James Lindsay and I am the Tax Design Lead for Revenue Scotland. This will be a recorded webinar to give a practical guide for our Scottish aggregate taxpayers who are undertaking cross-border activity. This guide will cover a number of different scenarios. I think we have 8 in total, and I'll be talking through the different administrative requirements for our Scottish aggregate taxpayers with regards to registration and making tax returns. The first thing I want to talk about is a key principle for the cross-border rules that have been put in place by the Scottish Government. And that key principle is that the cross-border legislation should avoid double taxation. And what I mean by that is, currently in the UK system, there's only the UK Aggregates levy, so we have one tax jurisdiction. Once Scottish aggregate tax goes live on the 1st of April 2026, we'll have 2 tax jurisdictions, one in Scotland and one in the rest of the UK. So if aggregates moved across the Scottish border, then there's 2 taxes to consider, and what these rules, which have been developed in conjunction with Revenue Scotland, Scottish Government and HMRC, what they're looking to avoid is that both Scottish aggregate tax and UK aggregates levy are applied at the same time. So ultimately, it's just one tax that should be payable. Another couple of principles that arose as part of our engagement during the development of the Scottish aggregates tax cross-border rules, where that stakeholders are very keen that the rules were kept as simple as possible, and that the administration would lie primarily with the quarry operators as opposed to the customers. Customers don't currently undertake any administrative requirements for UK aggregates levy, and stakeholders want to maintain that as best as possible. So the rules, as you see as I'll talk them through, have been designed with those principles in mind. The other thing I should mention is that the scenarios all go in one direction. What the scenarios I'm talking today, they'll move as aggregate is getting moved from the rest of UK into Scotland, and the reason for that is that when the tax was first conceived, the approach was for the country of destination to be the country that retains the tax in a cross-border movement of aggregate. So aggregate that moves from rest of UK into Scotland will be the Scottish aggregate tax that's payable, and because it's a Scottish aggregate tax is ultimately payable, it's the one that applies best for Revenue Scotland. It's the movement of aggregate that applies best. I should say that HMRC has put rules in place that essentially mirror what Scottish Government has done with their rules. So whatever I'm talking about today in terms of movement from Scottish aggregate from the rest of the UK into Scotland, the same principles apply and the other way around. Okay, so let's go to scenario 1, and this is the most basic scenario. It's what we call direct supply, and what I mean by direct supply is that there are only 2 players in the supply chain. There's the supplier and the customer. We will come on to talk about more complicated scenarios where there's more than 2 persons in the supply chain, but right now there's only 2 and it's a direct supply. And in this scenario, we've got a quarry operator based in the rest of the UK who has moved or supplied aggregate to a customer based in Scotland. And what we'd require here for the quarry operator to do is to register for both Scottish aggregates tax and UK aggregates levy. They would I'll put a return into for the UK aggregates levy, but make a tax credit claim in that return for the cross-border movement of aggregate into Scotland. And then they would also put a return in for Scottish aggregate tax and pay the Scottish aggregate tax due. So going back to one of those principles or that original framework for the tax when it was first conceived, it's a country of destination that ultimately will retain the tax. So in this case, it's the Scottish aggregate tax that's ultimately payable. So as a summary, the quarry operator will register for both Scottish aggregate tax and UK aggregates levy, but they'll make a tax credit claim for the UK aggregates levy in their UK aggregates levy return that will signify the movement of aggregate across the border into Scotland, and Scottish aggregate tax will be payable by our UK-based quarry operator as part of their Scottish aggregate tax return. And I should also kind of cap this off by saying that the customer will be exempt, or anyone down the supply chain will be exempt from both the UK aggregates levy and the Scottish aggregate tax once the charge has been borne on the registered quality operator. Moving on to scenario 2, and again this is the direct supply scenario because there's only two parties involved. But in this, the difference in this case is that the quarry operator hasn't delivered aggregate into to the customer as in scenario 1. It's the customer that's come to the quarry site and collected. And the difference here in terms of administration, there may be no difference in terms of putting in a return and registering. And if it was the case here at an RUK quarry site, it's a Scottish customer that's come and collected, then there would be no difference. It would be the quarry operator would register for both Scottish aggregate tax and UK aggregates levy. They'd put a tax credit claim in for the UK aggregates levy to HMRC because the aggregates moved across the border, and they would pay the Scottish aggregates tax as part of the UK Scottish aggregate tax return. The difference for scenario 2 as compared to scenario 1 is that the quarry operator does not automatically know in scenario 2 where the aggregate is going. In scenario 1, it's easily determined for the quarry operator that the aggregate is moving from RUK into Scotland. That's the destination of Scotland because the quarry operator is delivering to a Scottish customer. In this scenario, the quarry operator doesn't know initially where it's going. It's the customer who knows where it's going. So what we would require the quarry operator to do would be to determine where that aggregate is going, would determine where the customer is taking that aggregate to by asking the customer where it's going to. We have put in our guidance a template declaration that you can use to get your customer to fill in that will demonstrate and evidence where the aggregate is going. Essentially, what we're looking for is as basic as possible as declaration. It's really a tick box that tells us the jurisdiction of where that aggregate is going. It's not the actual address, it's the jurisdiction, so whether it's going to Scotland or whether it's going to the rest of UK. And a signature by the customer indeed. And from that, the quarry operator would have undertaken their due diligence in determining where the aggregate has gone. And once you've determined where the aggregate has gone, you can then know what tax to pay. So in this scenario, this customers went back to Scotland, so it's the Scottish aggregate tax is ultimately payable. And as I said, it's a UK aggregates levy tax credit is made, and Scottish aggregate tax is payable in tax return. If that customer was to say, yeah, I'm not going to Scotland, I'm delivering the aggregate to another place within the rest of the UK, then it would just be UK aggregates levy that's payable, and Scottish aggregate tax would have nothing to do with it. So the difference with the collection is that the quarry operator had to undertake that extra bit of administration to determine where the aggregate is being delivered to. We do understand that it's extra administration than what is currently in play for the UK aggregates levy, but we've designed the requirements to be, again, as simple as possible, going back to those principles, and it's just really a tick box exercise. You don't have to use the template as in a guidance. You can use another reasonable means of recording where the aggregate's going to. It could be digital means, it could be part of your order form. It's just as long as you have records there that can demonstrate that you've undertaken your due diligence to determine where that aggregate is going. Okay, moving to scenario 3, and it's very similar to the scenario 1. You might hear me say that a few times throughout this presentation because a lot of the scenarios are essentially based on that scenario 1. But scenario 3 is as a movement from a site based in the UK to a site based in Scotland, but the difference is that site based in Scotland is a connected site. And what I mean by connected site, is that the site has been registered as part of the same tax registration, or whether it's UK aggregates levy or Scottish aggregate tax registration, is under the same registration. That's classed as a connected site. And for the UK aggregates levy at this point in time, so this has been recorded before if Scottish aggregate tax goes live on the 1st of April. under the current rules, if a UK aggregates levy quarry operator has another site, whether it's a quarry site or maybe it's an asphalt plant, concrete plant, and it's registered together, they can move aggregate between those sites without incurring UK aggregates levy. The UK aggregates levy would arise at the point where from that connected site they move off to another site, or maybe they mix it into a product on that site. That's when the UK aggregates levy would arise. It's not at the point it's moved off the originating site. The difference in this scenario is now there's a border, a tax border in play. You moved it from a quarry operator that's based in the rest of the UK, a quarry operator site that's based in the rest of the UK, to a site that they own, let's say, based in Scotland. And what we'd expect the quarry operator to do in this scenario is to indicate to the tax authority that they have moved aggregate across the border. And because they're moving it from RUK into Scotland in this scenario, it would be an indication we go to HMRC. You're going to HMRC and saying, I have moved aggregate from RUK into Scotland, therefore I want to claim a tax credit. And is that tax credit that indicates, that tax credit claim that indicates to HMRC that you are moving aggregate across the border. And HMRC is introducing a new box in the return where you can specify that it is a cross-border movement of aggregate. And in order to facilitate that connected site approach for Scottish aggregate tax, you would register with Scottish aggregate tax and register both your quarry site and the connected site, and you can still move that aggregate to that connected site without incurring Scottish aggregates tax. And it's just if you move it off that site, or again, I say mix it on that site into a new product, at that point Scottish aggregate tax would be payable. So as a summary, you would be registered for Scottish aggregate tax and UK aggregates levy, make a UK aggregates levy tax credit claim because the aggregates moved across the border, and you would register both your originating site and connected site for Scottish aggregates tax, and you can move aggregate between the two without incurring Scottish aggregate tax until such time as you commercially exploited it on that connected site. Moving on to scenario 4. This is what we can now call an indirect supply, and I mentioned before that's where you have more than two parties in the supply chain. In this case, there's an intermediary, which could be a builder's merchant, it could be a bagging plant, or any other type of intermediary where you've got a quarry operator selling to an intermediary who then on-sells to someone else. And in this case, let's say the quarry operator is based in RUK, so is the intermediary, and let's say it's a builder's merchant, and then that builder's merchant then sells from RUK to a customer in Scotland. Now, it looks a bit more complicated, but the actual administration is just as simple, and it's what we'd expect for is the quarry operator to again determine where they're selling aggregate to. In this case, it's a RUK quarry operator selling to an RUK based builder's merchant or other intermediary. And all the quarry operator needs to know then is that, well, I am based in RUK, I've sold to an RUK person, therefore it's UK aggregates levy that's payable. And that's the end of the consideration for the quarry operator. And what would happen then is that both the intermediary and any customers further down the supply chain would be completely exempt from UK aggregates levy. They'd be exempt from Scottish aggregates tax, and it would just be the tax be borne on the quarry operator, and in this case it's UK aggregates levy. Scottish aggregate tax really wouldn't come into it at all in this scenario. And that's it for scenario 4. It looks a bit complicated, but really it's just the quarry operator needs to determine where they're selling aggregate to, and if it's in the same country of jurisdiction, it's just the tax in that jurisdiction that's payable, and that's the end of the story. Scenario 5 is a different flavour of scenario 4, where there is an intermediary, but instead of the quarry operator selling and delivering to that intermediary who then sells on to a customer, it's the customers approach the let's say builder's merchant and ask for, let's say, a large amount of aggregate, but that builder's merchant doesn't have that aggregate in stock, for example. So they come to a quarry site, a quarry operator in the same jurisdiction, and request a price for both sale and delivery to the builder's merchant's customer. And what we require there in this scenario for a quarry operator, and it's very similar to scenario 1, in that it's essentially a direct supply. The quarry operator knows they'll be easily determine where that aggregate is going because they're supplying it, they're delivering it to a customer. In this case, a customer based in Scotland, so they know it's going to Scotland, therefore they should know it's Scottish aggregate tax is payable. So the quarry operator will register for Scottish aggregate tax and register for UK aggregates levy. They will make a tax credit claim for UK aggregates levy to HMRC to indicate that aggregates moved across the border. And they will pay Scottish aggregate tax and make a Scottish aggregate tax return to Revenue Scotland. And that'll be the end of it for the quarry operator. The intermediary and the customer, again, like all the other scenarios, they'll be exempt from both UK aggregates levy and Scottish aggregates tax because the quarry operator has paid the tax for the movement of that aggregate. And that's it for scenario 5. Moving on to scenario 6, and again this is very similar to scenario 1 in that there's a quarry operator based in the rest of UK and it's moving product to a customer based in Scotland. The difference in this scenario, however, is it's not raw aggregate that's been moved from the quarry site to the customer. The quarry site has used that aggregate to create a new product and move that product across the border. So for example, the quarry site could have, say, a concrete plant on site, and they've used the aggregate from the quarry to create concrete and then move the concrete across the border into Scotland. Now, as the site's based in our UK, there'll be a point of commercial exploitation, that's the tax point, when they mix that virgin aggregate into concrete. And it'll be UK aggregates levy that's therefore payable at that point. And then when the concrete is moved into Scotland, it has absolutely no bearing on both UK aggregates levy and Scottish aggregate tax because UK aggregates levy has already been paid on aggregate when it's been mixed, and the material that's been moved, which is concrete, isn't actually classed legislatively as aggregate for the Scottish aggregate tax or UK aggregates levy, so it has no bearing on the taxes themselves. And that's it for scenario 6. Scenario 7. Again, this is a direct supply scenario, and this is where, and the difference here though is that the quarry operator has moved aggregate or supplied aggregate to a Scottish customer, but that customer is undertaking a prescribed industrial or agricultural activity that allows a tax credit to be claimed. Now, in an unusual scenario, so if we forget the cross-border transaction at this point in time, under current rules for UK aggregates levy, which will be exactly the same for Scottish aggregates tax when it's in place, if a quarry operator sells to a customer who is undertaking prescribed activity, such as, let's say, glass manufacturing, the customer can sign a declaration, give it to the quarry operator, and then they can make a tax credit claim that will bring down the charge for the aggregate being sold. The difference in this scenario is that the aggregate is being sold across the border, so in this case from our UK to Scotland. And not only will there be a tax credit for the prescribed use, there'll be a tax credit available for the movement of aggregate, a cross-border tax credit. So the question is, what should the quarry operator do in this scenario? And the principle that we'd be looking for the quarry operator to use is that they should always report aggregate that's been moved across the border. And the way they do that is by indicating on a tax return that they want to claim a cross-border tax credit. And if they're based in our UK and they're moving aggregate to Scotland, or supplying aggregate to Scotland, I should say, then they should make that tax credit claim on their UK aggregates levy return. And that'll let HMRC know that aggregate's been moved to Scotland. And then the quarry operator in this scenario can make a tax credit claim on their Scottish aggregates tax return for the prescribed industrial use. So the construction site, the customer may be a construction site, but we said, I think, glass manufacturer, an example we said, so let's say the glass manufacturer can make that declaration for the quarry site to keep, so they can make that Scottish aggregate tax credit claim for the prescribed use. So in summary for this, the originating site would register for Scottish aggregate tax and UK aggregates levy if they've not already done so. They'd make a UK aggregates levy cross-border tax credit claim. and then make a tax credit claim for the Scottish aggregate tax return in relation to the prescribed industrial use. And in that way, the tax position is exactly the same. Essentially, there's no tax to pay. Okay, moving on to the last scenario, and that is scenario 8, and it looks possibly the most complicated scenario. There's a lot of movement here, and what the scenario covers is aggregate that will move across the border and might come back and might go back again. So it could cross the border multiple times. For example, you could have a quarry site based in RUK who's selling to a customer, let's say a depot, it's a third party based in Scotland. And that depot then transports aggregate to different sites based in Scotland and based back in the rest of the UK, dependent upon where the aggregate is needed and when it's needed. And it could deliver that, take the aggregate back to RUK and then not utilise it all and bring it back to Scotland and bring it back to RUK when needed. So there could be a lot of movement, which could create complexity. But again, this is very similar to scenario 1, and going back to those principles of simplicity and keeping the administration with the quarry operator. What would be expecting for the quarry operator in this scenario is to determine where they're selling the aggregate to, just like all the other scenarios. And in this case, they're selling the aggregate to a customer based in Scotland, so they should know that Scottish aggregate tax is payable. And it's very similar to scenario 1, or exactly the same as scenario 1, then make a tax credit claim, or they'd register first for both HMRC and Scottish aggregate tax if they've not already done so. Make a tax credit claim for the UK aggregates levy paid to HMRC, and they would pay Scottish aggregate tax for the aggregate we moved into Scotland. And that's the end of the consideration for the quarry operator. The third party would then be exempt from both Scottish aggregates tax and UK aggregates levy, no matter where they move the aggregate to. If they move it within Scotland, down to RUK, down to RUK and back, it just doesn't matter. The tax has already been borne by the quarry operator, and therefore any further movements are exempt from both Scottish aggregate tax and UK aggregates levy. So as you see, although it looks complicated, the actual administration is fairly straightforward. And that's all the scenarios that we have in this webinar. I hope that was helpful. I would say what we, although if you don't, or if you do have an issue after seeing this webinar and after reviewing the guidance that we have, and they've got links on this website, on this slide, which has links to our website, which is revenue.scot, where you can find our guidance. Unfortunately, you won't be able to click the links here, but it gives you a link to our website where you can find the guidance. Also, we have a link to our email, which is sat@revenue.scot. If you do have any further questions, any further issues with cross-border transactions or just the administration of the tax itself, then you can please do reach out to that email address, and we'll seek to answer your query as quick as possible. Our contact, we also can phone in, so our website will give details of our telephone line where you can contact us there as well. So if you do have any further queries, please do get in touch. Thank you.